Hello, my name is Justin McCarthy. I'm a lawyer in Massachusetts, and today I want to give you 3 tips if you're considering having a last will and testament drafted. The first tip is that the will should be brief. It should be about 3 or 4 pages depending on the formatting, and all it should do in those few pages is appoint a personal representative. So this is the person who's going to administer the estate when you pass away. They'll file paperwork with the court, meet with the attorney, deal with the clerks at probate, and so on. It should name your heirs, and these are the people who are going to inherit your property. You should have as few heirs as possible. So make sure your property goes to your loved ones, your children, your spouse, whoever it may be, but avoid giving gifts to too many heirs. So you don't want to leave a gift to your church and your Rotary Club and the Audubon Society and distant relatives and so forth. Okay, that's going to make probating the estate much more difficult. Right? More people are going to need to get notice and be involved in the process. The will should also eliminate some of the additional requirements put on the personal representative, such as the need to get a license from probate court to sell real estate. The need for bond and surety can also be eliminated in the will. So that's tip number 1. Keep the will brief. Tip number 2 is use plain language when drafting the will. So if your lawyer drafts the will for you and you read it and you can't understand any of it, it just has these long-winded sentences that run on and on and on with a bunch of gibberish in it, that's not good. It's going to not just confuse you, it's going to confuse your heirs, it's going to confuse the clerks when they look at it, it's going to confuse other lawyers when they read it, and it's going to leave the will open to different sorts of interpretation and much more scrutiny. So the lawyer should really use plain language that anybody could understand. And of course there's going to be phrases in there that you may not understand, but that's okay if there's a word or two that you don't grasp, so long as the overall language of the will makes sense. And lastly, you should never draft the will yourself. You should have a lawyer do it for you. I see all the time probate files that are enormous because somebody tried to cut corners and save money by not having a lawyer draft the will. They messed something up, something that seemed trivial was actually significant. They left it out of the will. They didn't get the language right, whatever it was, and it just caused chaos in the probate process. It makes much more sense to have a lawyer do it. And if you shop around, you'll find that lawyers are very, very reasonable with their pricing for drafting wills. Some don't go directly to the first lawyer you talk to. Speak to 3 or 4 different lawyers. Ask them how much they'll charge you, and if it's a straightforward will, it should cost you a couple $100 at most. All right? So 3 tips again. The will should be brief. It should be written in plain language, and never draft it yourself. If you have any other questions, send me an email, leave a comment, and I'd be happy to respond to it. Thank you.